Good afternoon. I'm happy to open our last panel for today. So it will be like in the previous panels, the presenter will have 30 minutes and then the commentator will have 10 minutes. So first, let me start by presenting Professor Jean L. Cohen. She is the Nell and Herbert M. Singer Professor of Political Thought and the Columbia University Department of Political Science. She specializes in civil society, sovereignty, human rights, gender, religion, and democratic constitutionalism. She is the author of many articles and books, including a book titled Globalization and Sovereignty, Rethinking Legality and Legitimacy and Constitutionalism. And last year, she received the Columbia University's Distinguished Faculty Award for Excellence in Teaching and Research.
Thank you. That's it.
Yeah, that's
it. Does this work?
Yeah.
Good. I have to say that I'm becoming more seduced by this sovereignty as trusteeship idea. If the trusteeship part is a part, but not a full-fledged reconceptualization of sovereignty. But maybe we'll get to this at the end. I think there's a dimension of trusteeship, but I wouldn't want to redefine it entirely as trusteeship. But anyway, so this is, what title did I give you? Let me see. Oh, Whose Sovereignty, Freedom of Religion, Church Autonomy, and the Contested Status of Sovereign Trustee for Humanity. Okay. Proliferating demands by the religious for exemptions from generally valid law should give us pause. Freedom of religion is the slogan, accommodation the key claim. We seem to be in multicultural territory. Accommodation implies that the protection of religious minorities from burdensome laws passed by secularist or religious majorities is the issue. Sometimes. But I argue that the multicultural minority rights frame cannot get at the deep structure of the most contentious demands, nor help us thematize the fundamental challenge they pose to constitutional democracy. Current freedom of religion talk assumes that religion is special and unique, quite apart from minority or majority statuses, and the demands have little to do with toleration or fairness. One problem is that accommodation may turn discrimination by or within religious organizations into a religious group right, involving exemptions for the religious, their associations and enterprises from civil rights, health, and labor laws. But there's another stake in freedom of religion talk, sovereignty. We face a 21st century version of a much older, periodically resurrected trope invoked to challenge the comprehensive jurisdiction of civil law, derided as absolute monistic sovereignty, this time of the liberal democratic state. What makes religion unique for the accommodationist is the presupposition of another and higher source of law, ascribed a dignity that requires deference and inter-sovereign respect. Immunity claims are framed in terms of rights, but at issue is no ordinary conflict of liberal rights. I focus on the logic underlying a new wave of exemption claims from laws required by justice in the United States that impinge on the rights of others and challenge the legitimacy and scope of democratic constitutionalism. So I'll begin with two Supreme Court cases. One decided in 2012 that foregrounds the freedom of the church. The other now before the court, about to be decided. Every day I look for this decision in the paper terrified, involving religious claims of two for-profit corporations from healthcare, religious exemption claims from healthcare legislation. I then review arguments as to why religious freedom requires constitutional exemptions from valid law, justifications by the religionists fuse rights talk with jurisdiction talk, reminiscent more of late medieval conceptions of corporate privilege and immunities than of modern liberal democratic understandings. Indeed, the point is to challenge monistic state sovereignty, its supremacy, and comprehensive territorial scope. I examine this critique and attempts to enlist liberal pluralistic principles to justify it. I then present my counter-arguments about sovereignty and rights, and I conclude, the last part of the paper is not quite fully developed, with a caveat about international freedom of religious discourse that mobilizes human rights, human dignity, and the concept of trusteeship, not to foster a new, tolerant, and responsible or accountable cosmopolitan inflected sovereignty, but to undermine the primacy of the political and of civil law over religion domestically and transnationally. It seems that in the transnational corporate religious view, the religious are the true trustees of humanity, protecting human dignity from market and status depredations. And so I'm a little nervous about this discourse. All right. In the 2012 Hosanna Tabor case, the court constitutionalized the concept of ministerial exception, applying it globally to the church, shielding it from liability under the American with Disabilities Act for a retaliatory dismissal of an employee who taught mainly secular subjects in a religious school. The issue, employment discrimination by religious organizations and the nonprofit entities. Title VII of the Civil Rights Act prohibits employment discrimination on the basis of race, color, religion, sex, or national origin, exempting religious entities that hire on the basis of religion. But this was the first time the court considered whether the freedom of a religious organization to select its ministers is involved in a suit alleging employment discrimination on other grounds. The court created a ministerial exception in the First Amendment bar to interference by the state in the church. That's its language. It stressed that the employee was an ordained minister rather than foregrounding her secular teaching functions, leaving it up to churches to decide who's a minister. The ruling blocks future constitutional challenges to employment discrimination by religious-owned organizations, as in a later case when a federal appeals court invoked the ministerial exception to uphold dismissal of a suit filed by a church pianist with no ministerial training or duties, who said he was fired in violation of the Age Discrimination Act and the ADA. The invention of the ministerial exception as a constitutional commitment is a radical shift in the logic of accommodation. Why? The court's rhetoric gives us the clue. Deeming constitutional freedom of association rights insufficient to protect expressive purposes of churches in selecting ministers, the court said that the First Amendment acknowledges religion to be special with respect to religious organizations' autonomy. The church, it said, must be free to choose those who will guide it on its way. At stake is no mere employment decision, but the internal governance of the church, and non-establishment prohibits government involvement in ecclesiastical decisions. The Roberts Court thus carves out areas of jurisdiction for churches in their corporate character, construed as a hierarchy or as a community of believers, over a wide range of persons, subject matters, institutions, constitutionalizing these as freedom of religion exemptions from civil rights and labor laws. Now, this seems to conflict with the notorious 1990 ruling in the Smith case, which rejected the free exercise claim of two Native Americans fired for using peyote in a religious ceremony and then denied unemployment insurance. The court denied that the individuals have a constitutional right to exemptions from valid neutral law that impinge on their religious practice. It argued that such a constitutional right would make the individual's conscience a law unto itself. Legislatures may, but they're not required to grant selective accommodation to religious groups. The Robert Court addressed its ruling's inconsistency with Smith by declaring that unlike government regulation of outward acts, supposedly the Smith case, selection of its ministers involves an internal decision that affects the faith and mission of the church itself. This is preceded by a genealogy that frames, this is in the decision, that frames freedom of religion in terms of the old jurisdictional battles between church and state in early modern England. The church was free in the 13th century, thanks to the Magna Carta, but lost its freedom with Henry VIII's Act of Supremacy of 1534. In other words, supremacy of the political. The American founders were allegedly reacting against the latter and reinstating the former when they crafted the First Amendment. So this robust assertion of corporate jurisdictional autonomy for religious organizations, together with the Hobby Lobby case now before the court, in which two for-profit business corporations, I can't say that often enough, demand a blanket freedom of religion exemption from the Affordable Care Act's contraception mandate, the Obamacare thing. These are actually both the progeny of Smith. For in response, Congress passed the infamous 1993 Religious Freedom Restoration Act, RFRA. Purporting to overturn Smith and restore the court's previous approach, RFRA institutes a new doctrinal standard for the court and a blanket statutory exemption solely for religious groups, requiring that neutral laws burdening religious exercise must serve a compelling government interest by the least restrictive means available. This is the most demanding test known to constitutional law. RFRA is the statutory basis for Hobby Lobby's challenge to the contraception mandate and for proliferating exemption demands by the religious. It was the product of a huge outroar. Well, I won't get into that. We can discuss that. So the court has never addressed religious exercise claims by for-profit corporations. I wasn't particularly surprised by that. It will first have to decide the threshold question of whether these are persons with free exercise rights. If it decides that they are, it has to go through the RFRA formula to see if the law substantially burdens religious exercise and if it used the least restrictive means in furthering a compelling interest. The obvious clash here is between the religious interests of the controlling stockholders of these corporations and their employees' rights to health care, gender equality, and their own free exercise. Note that the corporations are not religious organizations or affiliated with any. While they may be legal persons for certain constitutional purposes, it would be a radical step were they deemed persons capable of exercising religion. Corporate lawyers can explain this to me. The controlling stockholders disapprove of certain contraceptives and invoke their religious liberty, arguing transitivity onto the corporation itself. Yet, one incorporates a business, I thought, to set up an autonomous entity legally distinct from its stockholders and to get economic advantages like limited liability, the corporate form acting like a veil, separating the rights and obligations of the former from the corporate entity itself. The owners want to have it both ways, to retain the economic advantages of the corporate veil and to pierce it for their personal religious purposes. But if owners can impute their religious free exercise rights to an inanimate business corporation, it seems to me that the argument for limited liability weakens as it's no longer a distinct entity, or maybe has its own religious persona. Isn't a political theological conception of the corporate really doing the work here? Note that accommodation claims don't contest the constitutionality of a law, but its applicability to religious groups. What justifies such blanket exemptions from valid law? Michael McConnell advanced the main arguments long ago and has been refining them ever since, exerting much influence on the court and on fellow jurisprudence. As he notes, such exemptions turn on the assumption that religion is special and unique, and he gives us three reasons. First, there's a special status the First Amendment itself bestows on religion. Though the Constitution doesn't say exemptions are mandatory, even allowed, he interprets it that way because even without targeting or coercion, facially neutral laws can discriminatorily burden unpopular religious minorities. Second, religious pluralism and liberty are among the core commitments of a liberal constitutional republic. The American polity, he insists, is not secular but pluralistic. Liberalism itself entails the value of religious plurality, and the American Constitution's religion clauses realize the logic of limited government dear to liberalism. In the epoch of the regulatory state, religious exemptions from civil law become all the more necessary for the protection of these liberal values. Since liberalism is a regime of fair procedures, the non-perfectionist liberal state must leave the development of conceptions of the good and morals to citizens, and it's not hard to guess which groups and associations he has in mind. Yet the heart of the matter lies elsewhere. The third explanation of why religion requires unique constitutional treatment is this. I'm quoting. While unable to establish a national religion, the liberal state also cannot reject in principle the possibility that religion may be true. And if true, religious claims are of a higher order than anything in statecraft. In short, religious claims, if true, are prior to and of greater dignity than the claims of the state. To deem that the state's authority is supreme in all matters would be to deny the possibility of that a transcendent authority could exist. Religious claims are thus special both because the state is constitutionally disabled from disputing their truth and because it cannot categorically deny the authority on which such claims rest. There's more. This premise is deemed the ground of liberal constitutionalism's commitment to the separation of church and state. Reference to a higher authority explains why religious commitments are unique and why the state must refrain from interfering in the governance of religious groups. In short, I'm quoting, the principle underlying the First Amendment is that the freedom to carry out one's duties to God is an inalienable right not dependent on the grace of the legislature. This applies to freedom of individual conscience as well as institutional church autonomy. By the way, church refers to all religious groups in this, Jewish too. At issue is the unique, unfree freedom of the religious who are obligated by another and higher authority to live and practice their religious law. Indeed, as Stephen Smith insists, the principle of religious freedom and separation between the religious and the secular, so basic to modern liberal constitutionalism, has its genesis and ground in the old two-realm theory of distinct jurisdictional domains divided between two autonomous corporate entities, the church, God, and the state king. Of course, this two-world theory of jurisdictional separation is Christian and theological, premised on the idea that the ultimate source of authority for both realms is God. The competing sovereignty claims and inability of religious or secular rulers to wholly dominate the other is what led to a fruitful legal pluralism, providing the terrain on which the idea of autonomous group rights could emerge. These are allegedly the sources and grounds of our liberal freedoms and modern constitutionalism. While the Protestant Reformation transformed the meaning of the church into a priesthood of all believers, dispensing with the corporate hierarchy, the church community is still the medium through which the word of God is preached. There is thus a shift rather than a break from the idea of freedom of religion and the mystical corporate community. As Smith puts it, the medieval commitment to separation of church and state, and hence to keeping the church independent of secular jurisdiction, was partially rerouted into a commitment to keeping individual conscience free from secular control. The medieval slogan, Libertas Ecclesiae, begat the modern freedom of conscience. Liberty of conscience and of the church, now seen as a voluntary association of believers, is also a sovereignty claim. At stake is the domain under the autonomous dominion of the Lord of conscience, Christ, the authoritative source for the obligations orienting religious conference, all off limits to the state's jurisdiction. Maybe that reminds you of Locke. Smith's point is to demonstrate the jurisdictional cast of the American version of religious freedom. Liberty of conscience, its connection to the older Libertas Ecclesiae, and to argue that all liberal constitutional commitments are predicated on this tradition, and are at risk due to the secularization of the secular and the monopoly of sovereignty by the modern state. Today, the secular state is not one of God's domains. It is now seen as non-religious, its legitimacy is secular, and the entirety of legal and political jurisdiction, sovereignty, belongs to it alone. Instead of political and legal pluralism following naturally from the two-world theory, we get monistic, absolutist state sovereignty with no limits other than those it chooses to put upon itself. Whatever freedoms or immunities the church continues to enjoy, including its legal status as a corporate entity, are simply concessions from the state. The commitment to religious liberty in such a context is insecure because the principle that anchors it, that religion is beyond the jurisdiction of the state because it's the realm under the authority of something that transcends the secular, becomes non-cognizable under modern sovereignty. Secularism turns jurisdictional matters into matters of justice that the state decides. So monistic sovereignty puts all our basic freedoms at risk. If this critique of state sovereignty sounds familiar, that's because it revives early 20th century pluralist arguments, Lasky, Cole, but especially that of John Fidges. Drawing on Gierke, the pluralists reached back to the medieval corporation to show that towns, universities, guilds, that they were neither derived from the state nor reducible to an aggregate of private individuals, the point being to counter both statism and individualism. They insisted on the sui generis real nature of corporate group life and what Fidges termed corporate personality, generated through association, not by state concession. The corporation is thus not a mere legal fiction. They are real social entities with autonomous agency, whether or not the state grants them legal rights or recognition. Now, Fidges' target was obviously British Erastianism, state control of the church, but he insisted that this establishment was insufficient to secure religious freedom. This requires acknowledging church's autonomous rulemaking power and corporate dignity. The deeper target was thus the doctrine of monistic comprehensive state sovereignty, the primacy of civil law, and the supposed concomitant privatization of religion and the atomistic conception of society. The sovereign territorial state triumphs through a Gleichschaltung, leveling the autonomous corporate powers within its territory with the formula cuius regio eius religio, culminating in the exclusive sovereignty and primacy of the state. The concept of sovereignty targeted by the pluralists then and now is thus the absolutist one, that posits a single, irresistible, inalienable individual source of law and power that is incapable of legal limitation, located in a single organ, and the non-existence of all other jurisgenerative bodies. Whether this organ is the king, a parliament, or the king in parliament, it's equally leveling and destructive of the rights of other social unions. In either case, all and every right is a creation of the one and indivisible sovereign. No prescription, no conscience, no corporate life can be pleaded against its authority, which is without legal limitation. I'm quoting. In every state, there must be some power entirely above the law because it can alter the law, and Fisher says to talk about rights against this is to talk nonsense. Freedom of the church, and indeed all our liberal freedoms, thus depend on rejecting all of this. The alternative pluralist view construes the state as a community of communities, society as a multiplicity of natural associations and corporate forms of group life, these groups are juris generative for their respective nomos communities. Legal pluralism, rather than monistic state sovereignty, is the appropriate frame for securing freedom to churches and to individuals generally. The autonomous jurisdiction of churches must be recognized by the liberal state. While civil authority may regulate their relations with other bodies, corporate, and to natural persons, corporate personality is not a gift of the state. The church has its own constituent authority. That's why no religious society could accept the absolutist claim of state sovereignty, for it puts divine law at the mercy of political convenience. Hence, the freedom of religious corporate societies to govern themselves entails exemptions from civil laws that would force the religious to violate their own law. Civil constitutional law must acknowledge this autonomy, but it is not its source. The contemporary revival of this discourse is striking, and its successes in court alarming and astonishing. This logic underpins talk of corporate autonomy and corporate freedom in the cases I just described. On the assumption that the secularist worldview is unable to justify or grasp our deepest commitments to liberty, the accommodationist project is to restore the traditional understanding on which our constitutional tradition allegedly rests. Recall the genealogy in Hosanna Tabor that framed religious freedom in terms of the early modern jurisdictional battles between church and state. The church, the dominant trope in this decision, is a corporate body, autonomous vis-a-vis secular government, entitled to immunities from public law. Now, to be sure, the church denotes any organized religious community. In a pluralistic religion environment, it references the many, not the one. But a religious conception of the corporate is operative here because the church enjoys those privileges whether or not it is incorporated by a civil law procedure. Accommodation is not a matter of self-limitation of the state, but deference to another jurisdiction. So my counter-arguments. Here I can only present my response to the two core claims that monistic state sovereignty is autocratic and leveling, the antidote being shared jurisdiction with religious nomos communities, and the jurisdictional interpretation of religious freedom as the first and paradigmatic liberal liberty. I argue that these caricature democratic sovereignty misdescribe liberal rights and freedoms and point to a form of legal pluralism, status group-based legal pluralism, that threatens both. So the concept of sovereignty involves an internal claim of a claim of internal supremacy of civil jurisdiction, signifying the coherence and unity of a territorial-based legal order and political community. The correlative of domestic supremacy is external autonomy, self-determination of the domestic constitutional order and political regime. State sovereignty is perforce relational and jurisdictional and juridical, presupposing a plurality of sovereign states recognizing one another as equal lawmakers, internationally and domestically. But the absolutist conception targeted by the religious legal pluralists locates unified sovereign powers within a single state organ, a monarch or parliament, and traces positive law and the unity of a legal system back to the arbitrary will of an uncommanded commander. This conception is indeed problematic. But the liberal democratic constitutional sovereign state doesn't presuppose it. It was anachronistic since the first modern constitutional republic emerged on the basis of the separation of powers, checks and balances, rule of law, representative government, and popular sovereignty as the principle of legitimacy, not to mention the division of powers entailed by federalism. Far from leveling social plurality, this political regime is the condition of possibility of a disincorporated, diverse, autonomous civil society. Modern constitutional democracies limit arbitrary rule by placing all state organs under civil law and denying sovereignty to any one of them. As a legal concept, state sovereignty pertains to the constitutional legal order in toto. Democracy ascribes internal sovereignty not to government, but to the people, not as an instance that actually rules, but as the sole source of the constitutional order and of law. The principles of democratic legitimacy and constitutionalism erect limits on every constituted organ of the state, hardly a recipe for autocracy. Indeed, as Kant argued long ago, the legal order of a democratic constitutional state must be seen as comprehensive and unified, thus creating a Rechtszustand, civil freedom, and the equal liberty of all as a moral and juridical condition. This is a Republican conception, quite different from the Lockean. But as the example of federal republics characterized by division and separation of power shows, this doesn't rule out division of competences among a plurality of instances or loci of public power. So when I say that sovereignty in a constitutional democracy is ascribed not to the government or any of its organs, but to the people qua constituent power, I mean that the referent is deemed to be the only authoritative source of constitutional law, which regulates all publicly valid coercive lawmaking and exercises of public power. This is the principle of democratic legitimacy. The absolutist autocratic conception of state sovereignty targeted by the religious legal pluralists elides the difference between constituted and constituent power, between the jurisdictional and the power political conception of sovereignty, crucial to a democratic liberal republic. By invoking a separate transcendent metasocial sovereign source, the accommodationist throws down the gauntlet not only to the supremacy and comprehensive scope of the jurisdiction of civil law, but to democracy's core legitimating principle. This is very disturbing. For jurisdiction of coercive law in a democratic polity cannot invoke an absolute transcendent metasocial source without violating the principles of democratic legitimacy and constitutionalism. Nor can we understand the limits erected by the Constitution to the scope of governmental power as an acknowledgement of an ultimate authority behind the Constitution that is other than the constituent power of the people and thus self-limitation. To view the religion clauses of the Constitution in this way is to resurrect the two-world theory and desecularize the civil state. That's obviously the point. At its deepest foundation, a project were to succeed that would take us out of the continent of constitutional democracy and into the domain of religious status group-based legal pluralism and potentially constitutional theocracy. Okay, on liberal rights and plurality, and then I'll end. Religionists portray religious freedom as the fundamental and paradigmatic liberal liberty, without which the whole edifice of liberal rights limiting the state would rest on quicksand. Yet they insist that religious freedom is unique, involving more than negative liberty. It's pivotal yet distinct because its legitimacy, as we saw, doesn't derive from the Constitution or from the demos, but from a higher authority whose sovereignty the constitutional guarantee acknowledges. Freedom of religion is thus an immunity involving privilege and jurisdiction, the right to say the higher law and to obey it when it conflicts with civil law. This is why religious autonomy can't be reduced to liberal rights of association, expression, belief, assembly, privacy, and contract. The circle is squared through a conceptual sleight of hand that collapses yet differentiates liberal rights with religious jurisdictional sovereignty. I beg to differ. Liberal constitutional democracy is committed to respecting individuals as persons, to designing legal and political institutions whose first virtue is justice, and to a fair distribution of the burdens and benefits of society. Associational plurality and the system of rights entailed in liberal democratic constitutionalism are, it's true, not concessions of the state. Liberal democratic theory construes them as matters of justice and is constitutive with popular sovereignty of democratic constitutionalism. But it doesn't ground them in an otherworldly source or view them as immutable, unchanging, objective rules and norms. Liberal rights and democratic constitutionalism are in a recursive, reflexive relationship. But, as Kant knew, liberal rights and democracy both presuppose a common civil law that treats people as equals, a rule of law that limits arbitrariness, and a civil society no longer represented as a body, yet that is irreducible to the agglomeration of atomized individuals. This involves a shift from the fragmented, hierarchical society of corporate orders of the Ständestaat to the modern sovereign state with a new type of constitutionalism, as I said, that makes rights a matter of justice under one civil jurisdiction, a new type of democracy based on political representation and equal citizenship, and a disincorporated, unbound civil society with new forms of societal plurality, voluntary associations, civil publics, social movements, and networks. Indeed, as Rand Herschel did correctly note, constitutional democracies are predicated on the lexical superiority of constitutional law. Hence, the unquote, unyielding reluctance of legislatures and judiciaries to accept as binding or even cognizable any potentially competing legal order that originates in sacred sources of identity or authority. No secular legal order or civil legal order, no matter how tolerant or otherwise open to providing exemptions and accommodations to religious believers, can accept with indifference a challenge to the very authority and supremacy of the civil constitution itself. While providing the terrain for the coexistence, of a plurality of identities and groups in civil society, liberal democratic constitutionalism is open to claims of justice that accommodate diversity as inclusion. So all accommodation is not rejected. But it has a constitutive antipathy to non-state law's competition, claims that seek to establish islands of jurisdiction outside the reach of the government. So neither religious freedom nor the separation of church and state, nor other civil liberties, nor the idea of a civil polity need rest on the discredited two-world theory. If traces of it underpin our laws and court decisions, these anachronisms should be dropped. The U.S. non-establishment principle and the free exercise clause and benign accommodations can be justified as respect for individual citizens' expressive and associational freedom and protection of religious minorities from discrimination, a risk in any society. But religious liberty, like other civil liberties, presupposes political secularism and the comprehensive scope and primacy of civil law, not Christendom. The shape of separation and the mode of regulation is a matter of democratic policy, fully within the remit of the only sovereign recognized by the Constitution, the people, to determine through their representatives. Okay. Accommodation is bemoan the shift from jurisdiction to justice, fearing that courts, like other civil associations, will be regulated under civil law. I have 2 minutes according to that. I'm almost finished. So the accommodations want to shift back. They're afraid of the shift from jurisdiction to justice, and that it's going to affect their privileges. To forestall this, they resurrect the discourse of church autonomy, a mystical understanding of the corporate community, underpinning freedom of religion and conscience, and a political theological conception of sovereignty and secularization, and neo-medieval claims to autonomous jurisdictional claims. This goes together with the strident insistence that liberal justice and the civil democratic state cannot be justified in secular terms. The idea is to resurrect corporate forms of legal pluralism under 21st century conditions and to shift back from justice to jurisdiction. The recent decisions by the pro-corporate, states' rightist, anti-regulatory Roberts Court read in this light are alarming indeed. The corporate religious want to get back control over this worldly domains, education, family law, and now even parts of corporate business law. The critique of state sovereignty points toward the erection of a transnationally organized religious legal pluralism, free at last from the primacy of the political and democratic civil regulation by the state or by secular transnational bodies. We shouldn't let that happen. One last point. Because, my concerns in the part of the paper that I'm not reading, with the discourse of trusteeship, if it's not concretized as to who you mean, is that the obvious candidate to fill in the sort of empty box is going to be transnational religious groups. Who is going to defend dignity of the human being against the market and the state but them? So I'm a little nervous about it, and I have one question which I hope can answer me at some point, the other part of my nervousness. And that is that democratic sovereignty involves a relationship of representation between the citizen and the representatives, very obviously. Of course, from the internal perspective, this means that you have, if you put up a trustee relationship, I suppose the citizens are the beneficiary, the trustee is the state, but there's a kind of third-party regulator in a trustee relationship that ensures that the state carries out its trusteeship duties, right? So there's always three in a trustee relationship, I thought. But from the internal perspective, democratic sovereignty and political representation, I don't think fits this. There is, of course, a dimension in which to ensure that the welfare of the population is taken care of by a trustee. This is a dimension of this. You know, the state shouldn't squander the resources, this sort of thing. That works, but it's not the whole. of a political conception of sovereignty. So my fear is that from the external perspective, vis-a-vis the world and administrative law, you can see this as a gain. But from the internal perspective, it might be a loss, even though we do need democracy-enhancing multilateralism. Okay, that was too much, but anyway.